Western Cape Judge President John Hlophe's attempt to challenge the Judicial Service Commission's finding of gross misconduct failed before the High Court in Johannesburg today. The court dismissed Hlophe's application to review the JSC's decision that found him guilty of impeachable gross misconduct. This is over a 2008 incident where Hlophe tried to persuade Constitutional Court justices to rule in favor of the then President Jacob Zuma. Hlophe has consistently maintained that his discussion with Justice Jafta and Gabinde were innocent academic discussions. Constitutional law expert advocate Michael Osborne joins us now for his perspective on the ruling's implication for Hlophe and indeed the judiciary. Advocate Osborne, good evening and thank you very much for your time and joining us tonight here on In Focus. First and foremost, let's talk about the merits of this particular application. Your view, were they justifiable? I mean, they raise, for example, issues of the presence of the Chief Justice and the Deputy Chief Justice, saying that particular meeting that decided to have Hlophe impeached was not properly formed, in fact was unlawful and unconstitutional.
Yes, that's correct. That was one of the arguments that was raised, that the JSC's decision was tainted insofar as judges were present on the panel that had an interest in the proceedings. The court rejected that and held that the JSC was capable of coming to an unbiased determination, notwithstanding that some of the persons on the panel had some prior involvement in the underlying merits. The other part of the decision, though, and arguably the more important one, is that the door is now open for Parliament to consider whether it wants to adopt the resolution of the JSC. Judge President Hlophe had argued effectively that Parliament may not rubber stamp the decision of the JSC, but Parliament must effectively hold its own trial to consider whether Parliament agrees with the JSC on the finding against Judge Hlophe. The court came to the conclusion as follows. Parliament has the power to decide to impeach Judge Hlophe on the basis of what the JSC has already decided. Parliament is not called upon, according to the court, to, as it were, rethink or reconsider the conclusion that the JSC had already come to, that he was guilty of misconduct.
So the legal advice or legal opinion that was sought by Parliament, I suppose in this particular instance, stands, because that's the legal opinion that they got, that theirs is really checks and balances, not to re-sit and rehear this matter, and then they move on to actually vote and thereafter have the President remove the judge. What is the process as far as the Section 177 of the Constitution is concerned of the removal of the judge?
Well, there would need to be a vote in Parliament, and 2/3 of the members of Parliament would have to vote in favour of impeaching the Judge President. It's a fairly simple, open-ended yes or no, will he be impeached? The judicial philosophy, or I should say the jurisprudence behind this, is that the JSC is a specialized disciplinary tribunal for these purposes that is fully competent to make a finding as to whether what Judge Hlophe did constituted misconduct. There's no need for Parliament to go down that road again. The narrow question now before Parliament is whether the findings of the JSC warrant the removal from office of the Judge President, which is what impeachment entails.
Yeah. What's the implication if the sought 2/3 majority vote is not acquired?
Well, then he will not be impeached. The matter could go back to the JSC, and the JSC could consider other lesser forms of sanction. It could be a reprimand. but Parliament itself only has a single decision, thumbs up or thumbs down to impeachment.
Now, what does this then mean? I mean, as far as the reading of what gross misconduct means, I mean, one of the arguments from Judge Hlophe is that the JSC used the wrong test of gross misconduct. Now that the courts have rubber-stamped literally the decision of the JSC, what does it mean going forward into how we interpret what gross misconduct is?
Well, I wouldn't say that the court has rubber-stamped the determination of the JSC. It considered the evidence that was placed before the JSC for itself. I should add, though, that this is not necessarily the end of the road. Of course, it's within the rights of the Judge President to appeal the decision of the High Court in Johannesburg, meaning that the matter could go to Bloemfontein, to the Supreme Court of Appeal. Thereafter, the matter could go to the Constitutional Court in Bloemfontein. So it's entirely possible, and I would think even likely, that this is not the end of the road.
Yeah. What would that mean? I mean, my understanding, you correct me here if I'm wrong, that the initial complaint was lodged by 11 Constitutional Court judges about 12 years ago. For this matter, if it indeed does go to that point where it once again has to go to that court for it to sit and hear it. I know it's not the court that brought it, but it's the individual judges. But what would be the implications of that?
Well, you probably would have the situation where the Judge Jafta, one of the complainants who still sits on the court, may have to recuse himself. The matter would then need to be heard by those judges on the court who had no personal connection to the events in 2008. Many of those judges, of course, have retired.
Yeah, indeed. And I suppose this goes to, again, answer the question why we have not seen a judge being impeached for a while. And it has not happened. This would be the first time that we actually see it happen. It's not really an easy process.
No, it's a difficult process. As far as I know, in all of South African history, even the pre-democratic history, a judge of the High Court has never been impeached. And it ultimately tends to resolve to a political matter in Parliament. And where the most recent case in which there was a possibility of a High Court judge being impeached involved Judge Makari, but he chose to resign voluntarily before the disciplinary process could take its course. And in the United States, too, where ultimately it's a political arm of government that has to take the decision as to impeachment, it has happened only 2 or 3 times in all of U.S. history, 220 years.
What then does this mean for the judiciary itself, Advocate, in as far as, of course, the debates that are currently going on around the judiciary, the independence of the judiciary, the integrity of the judiciary, that this matter is prolonged for so long, and this cloud hanging around the Western Cape Judge President?
Well, I think the conventional wisdom would be that from any point of view, it's undesirable that a complaint lodged in 2008 would still be in the courts in 2022, and indeed that appeals might still be going on in 2023. It's far from satisfactory, and it's been caused in some measure by the fact that Judge Hlophe has taken previous decisions adverse to him on appeal. And the appeal process is inevitably slow. There's 2 levels of appeal, up to the SCA and up to the CC. And the roles of both of those courts are fairly full. And you could well wait 6, 8, 12 months between the time of the lodging of an appeal and a determination. So that's the reality. They say justice delayed is justice denied.
Yeah.
And justice certainly has been delayed here.
Well, there are, of course, other debates around whether or not this is a self-serving challenge or application or challenge of the process. The judge is well decorated, I think over 20 years of experience. Is there a sense that there is an abuse of the JSC process or even the court process here?
I wouldn't want to opine on that. The fact is that the judge president, like any person, is entitled to due process, and the structure is set up, for better or worse, that we have the opportunity to appeal up to 2 courts, and the structure is also set up in such a way, as I've already mentioned, that it's a laborious process. And I think the judge president, whatever you think of the merits of his case, is quite entitled to exhaust all of his appeal opportunities.
Advocate Osborne, I appreciate your time. Thanks so much for coming on.